Go ahead, Ryan.
Great, we'll call the state of Wisconsin versus JAVION Briggs. It's 26 CF 1674 appearances.
John Baik for the state.
Mr. Briggs in person with counsel Bill Ginsberg. We got a copy of the complaint. Waive its reading. Plead not guilty on any of the misdemeanors. The address should be 917 West Main Street, number 202, Sun Prairie, 53590. I would jump up and down and say that there's not even sufficient facts in the criminal complaint on the recklessly endangering safety, but I'm not gonna. I think the court will probably say, well, there's probable cause, so we'll take it up in the bail arguments.
Well, I mean, you can make an argument. I review the complaints ahead of time. I guess I thought there was probable cause, but I'm happy to be proven wrong. But for purposes today, we'll make findings of probable cause. What's the state's position on bail?
State's requesting $10,000 cash bail with the conditions that the defendant have no contact with his co-defendant, Gabriel Stewart, that he have no contact with MB Maple Bluff Police Department, Officer Nicholas R as in Romeo, unless required by official law enforcement duties, and that the defendant not use or possess any dangerous weapons, as that term is defined by statute. Your Honor, Mr. Briggs here has prior convictions for fleeing and eluding. He's charged with 5 felony bail jumps here. Specifically in this case, he fled from a traffic stop while armed with a loaded and chambered firearm. He physically resisted law enforcement and wrestled over control of said firearm with law enforcement, endangering not only their lives, but also the public in general. It's abundantly clear from the alleged facts that it is an extremely dangerous incident within the community, combined with his prior felony records, which of course bar him from owning a fire or possessing a firearm in the first place. There's a clear failure to appear risk here when someone is fleeing from police and resisting with them, struggling over a firearm. There's a danger presented to the community, and therefore significant cash bail is justified.
Great, and Attorney Ginsberg.
Judges, your court commissioner, this is a real interesting bail argument. Mr. Briggs, back in 2020, was charged with first-degree intentional homicide. And amazingly enough, he turned himself in, and the cash bail on that first-degree intentional homicide was $7,000. And he posted it and showed up at his court appearances and never missed court. Now, subsequently, it was increased when there were some other pretrial services stuff, but it had nothing to do with missing court. So it's hard to believe that more cash bail is necessary on this than on a case with a mandatory life sentence. Eventually, that homicide was dismissed after we picked a jury, we had a mistrial, and when prior to starting again, the state dismissed the case. We pled to some bail jumps, and then there was the eluding from 2019, and Mr. Briggs was put on probation for 3 years in 2022. He completed probation. So it's very unusual that he's shown that he will show up for court when out of custody on a first-degree intentional homicide case. And he completed 3 years of probation, which just finished last year. So he's really a person who's not going to flee on these cases. Now, the serious charge in this complaint is the recklessly endangering safety. And, you know, you can see I did all my homework for this. It says that he had to endanger the safety of another person. And what the complaint says is the officer is going to tackle him, and JAVION allegedly reaches for the gun. And to me, the obvious inference is I'm going to either throw it away, right? People do that even in this complaint. That's what Mr. Stewart allegedly did, threw a gun away as he was running away. Or he's going to get control of it and make sure he doesn't get killed. I don't think the complaint suggests that JAVION did anything to recklessly endanger the safety of the officer. And that's not to say that the officer, when he realizes the guy is tackling has a firearm, isn't concerned for his well-being. Thank God you don't have another shooting of an African-American in the community. But I think that count is overcharged. I think that Mr. Briggs is a lifetime resident. He has never missed court on his cases, including the homicide. I don't know if it sounds outrageous to say signature bond, but he's gonna show up in court. He's not gonna flee for this one.
Right, any response?
And no, he has 2 children that live in the community. He has a 4-year-old and a 1-year-old.
I rested my previous arguments.
All right, just give me a second.
You want the case number for that homicide?
I was just gonna look all of it up. You mentioned some bail jumps.
Right, but that was they were because while out on bail, I forget what, there were some other cases that came up. So the bail jumping wasn't skipping court.
Right, but I'm curious because it's an Act 3 eligible offense and the history of non-compliance with bail, I think, becomes relevant in an Act 3 analysis.
I forget what the bail jumps were. I'm guessing that he had some open cases. So yeah, he would have had open cases when the homicide case came up. And then at that point, in the homicide, he had a weapon, and that automatically was the bail jumps, is my recollection. I could be wrong.
Yeah, so it looks like, and I'm not counting the dismissed in red end, looks like he's been convicted previously about 5 felony bail jumps and 1 misdemeanor bail jump. That's concerning. You've got the eluding behavior and the resistive behavior here. It's a pretty persuasive argument that we shouldn't be setting cash bail higher than what was apparently good enough to get him to court on a much more serious charge. But I see it as a cash bail case on an Act 3 analysis where somebody has picked up multiple bail jumps while they've been out on bail in serious cases, but I'm going to set it much less than the state's asked for. I'll set it at $3,500. I'll order a no contact direct and direct with Gabriel Stewart and a no contact direct and direct with Maple Bluff Police Officer Nicholas R., except as needed in his ordinary duties as a law enforcement officer. And then the user possess any dangerous weapons. I think it's a real amount of bail here. It also provides the protection of the public incentive that he comply with all these conditions and not pick up any other cases. Because if you do, then all of that money can be subject to forfeiture. In fact, the statutes say shall forfeit it. What about time limits for?
Waive time limits.
Right, the clerk will let you know what we've got available for a status date.
Right now, I'm looking at August 24th, 2/20.
One quick second.
I suppose if you decide you want a prelim, you can send something in, and if you decide you don't want a prelim, you can send something in, and I don't really know what the third option is.
What time on the 24th?
2/20.
Sure.
Okay, we are adjourned.
Great. VERHELST is next. Yeah. Price. Price. Oh. Say that in the West.
Great, we'll call the bail hearing for Jaya VERHELST, 26 GF 37050 appearances.
John Baik for the state.
And Gia VERHELST appears in person with her attorney, Tim Kiefer.
Right, there is a public safety assessment. I don't know if you've got a copy of that. If not, the public defender probably has that. This was scheduled for an initial appearance. We don't have a complaint. There was a probable cause affidavit that Judge Trammell found probable cause for. So does the state know when we might have a criminal complaint or a decision on that?
Yes, so the notes I have here are, we're requesting an initial appearance in 30 days. We would be asking for a signature bond with certain conditions, which I can state now. Would be a signature bond with no contact with Jared, JEROD, or Patricia W. That the defendant be banned from Maniposa Daycare, MANI POSA, and that the defendant not post on social media and other forms of electronic communication regarding Jared W. or Patricia W. or that aforementioned daycare.
And Attorney Kiefer, any objections?
No, I think Mariposa is spelled with an R, not an N, but
Yeah, that's what it looks like according to the PC affidavit. So we'll order a signature bond conditional be a no contact direct or indirect with Jared and Patricia W. A ban from the Mariposa daycare and that you not post on social media about the Mariposa daycare or Patricia or Jared W. I don't know whether you're gonna get charged with anything or not. We'll find out more in 30 days. These are serious charges. You want to make sure you're abiding by these bond conditions. Otherwise, you can get charged with felony bail jumps, even if you don't get charged with the stalking. Do we have the out of custody IA date?
Right now, I've been looking at September 30th, Thursday.
Right, does that work?
let me quickly check. While I'm doing that, Your Honor, is the probable cause finding, I can see Judge Trammell already signed it, but is that something that can be litigated today, or is that not subject to challenge today?
Well, that would be very weird for me to review the judge's decision on that very document.
But the judge's decision was not made with any input from me.
Yeah. Well,
And by the way, September 3rd is fine.
I haven't given that some thought. If you want to make an argument, I'll hear what you have to say about that.
Sure. So I'm only addressing the stalking charge because Judge Trammell did not find probable cause for the obstructing, so that's dropped away. So there's really two aspects of it. One is the claim that the Woolridges have received these spam emails, enrolling them in various subscriptions and things like that. But there's nothing in the probable cause affidavit that connects that to anything that my client did. It just says that they received these various emails, but there's no indication that these emails were in some way traced back to Ms. VERHELST. So I think there's no probable cause there because there's no nexus between those. Then with regards to Mariposa daycare, there are a number of complaints that were filed with various government agencies under pseudonyms. And my argument would be, to the extent there would be a victim of that, that would be Mariposa Learning Center. There's no allegation that any complaint was filed against either of the Woolridges personally, or that my client even knows that the Woolridges are connected to Mariposa Learning Center. So the victim, if any, would be Mariposa Learning Center, not these two individuals. And second, when I look at the list of things that constitute stalking, I don't see anything where filing a complaint with a government agency, even using a pseudonym or anonymously, would fit the definition of stalking. In these cases, the victims, to the extent there could be a victim, would be Department of Children and Families, or the people that receive these complaints, not Mariposa Learning Center or the Woolridges. And finally, I don't believe there's anything illegal about submitting an anonymous complaint, submitting an anonymous review, submitting a review online that's under a pseudonym. I can think of a website that does reviews of lawyers, and it is specifically allowed to post reviews of your lawyer on that site using a pseudonym or anonymously. So I don't think that any of the elements with regards to stalking are met here. So I don't think there is probable cause. And I understand the judge made a probable cause statement, but I didn't get to be there in the room when the judge did that. And I think had I been there, been able to make these arguments, there may have been a different result. So you have more information than the judge had, and when the judge was just sitting in chambers without the other side of the story.
All right, well, I'm not sure that's what the purpose of the Riverside review is about. It doesn't require the defendant to be present or to have an attorney who makes arguments in regards to the probable cause. Attorney Baik, any response you want to make?
Well, Your Honor, quite frankly, I actually don't have the Riverside affidavit in front of me. So,
From off the top for you, we just say name on it if you'd like one.
yeah, I would appreciate that before I make any argument.
Just one moment.
So Judge, I do think there's probable cause of stalking as stated in the Riverside affidavit here. I mean, it's alleged between February and June of this year that the defendant submitted over 400 emails, enrollment in adult entertainment websites, vehicle loans, pledges of fake money or money to nonprofit organizations, excuse me. There's very detailed information about how it caused the victim's emotional distress, and I won't go into detail because I think it's all available to the court as well as the defense attorney. So I think there's really no doubt in my mind that there's course of conduct here, and that it has caused emotional distress given these very specific sort of remedies that the victims have sought out or attempted to seek out. So I would ask that you find probable cause in this affidavit.
All right, any response, Attorney Keeper?
Yes, it is not true that in the four corners of this affidavit that it says that my client sent these 400 spam emails. It says Patricia Woolridge has received over 400 spam emails. It nowhere says that Ms. VERHELST sent any of these emails or initiated having these emails sent. That's the part that's missing, and that's why it fails on these spam emails. I agree. If it was shown that the spam emails originated with her, then there would be probable cause, but that's not within the four corners of the affidavit.
All right, well, one, I don't know that you're entitled to the review of the Riverside affidavit. That's not ever been a requirement of the procedure for Riverside review within the 48 hours. There's arguably somewhat conclusory, but there's always been a lesser standard of probable cause for Riverside review than what has to be in a criminal complaint. But they allege that there's numerous emails and fake personas that this defendant was ultimately tied to, and that part as to how they were tied to it is certainly conclusory, but at this level of probable cause for Riverside hearing, I think that's sufficient. And I think there's at least an inference that all of those other additional emails that come along with multiple spam and fake emails that are tied to the defendant meet the level of a course of conduct. And there's allegations that the victims suffered emotional distress as a result. There's certainly an inference that somebody who had this beef with the Mariposa Learning Center would have been aware of who these people were, the owners of that. So I'll deny the probable cause, and certainly we'll either have a complaint or not, and you're certainly free to raise it at that point. And I think they've got to have much more in a criminal complaint for the matter to proceed. I think you also get de novo review if I even had the authority to review it to begin with. We are adjourned. Thank you.
Diakite is next, Diakite.
They'll let you out today then.
Diakite. Diakite.
Yeah. Yellow.
How are you?
Great. We will go on the record in the state of Wisconsin versus TANI DIAKITE, 26 CF 1630 appearances.
John Baik for the state.
Your Honor, let the record note this is a special appearance. Mr. Diakite is here in person and represented by attorney A. Stephen Porter.
All right. And when you say special appearances, you have to do something to get you retained for future appearances?
No, this is a special appearance to preserve any objections to the complaint and
Okay.
the jurisdiction of the court.
And the reason I asked is I wanted to make sure that he had the public defender info. If he hadn't had you retained.
Oh, yeah, no,
I
I'm
wasn't gonna have counsel
I'm
going
retained.
forward.
Yeah.
All right. And do you have a copy of the complaint?
I do will waive the reading.
Do we have a good address on that?
Yes,
All right. And I don't know if you got the public safety assessment, but if not.
I just got
you
it.
should have
Yes.
that.
So
All right.
of course, we hope we're getting a signature bond here.
All right, so probable cause was already found. This went out on a complaint and warrant. The public safety assessment report recommends a signature bond. What's the state's position on bail?
Your Honor, the state is requesting $2,500 cash bail with the condition that the defendant have no contact with victim one. This is a third-degree sexual assault. This is mainly as protection of the public argument as well as protection of the victim. It's alleged that, or it's my understanding that the defendant and victim have been dating for about 6 months. The defendant asked the victim to stay over at his house, which they agreed. But the victim explicitly said that they wouldn't engage in any sexual intercourse. Despite that, during when they were together, the defendant climbs on top of the victim while she's laying on her back, putting his full body weight, begins to pull her underwear. The victim is saying no and stop many times, but the defendant persists and inserts his penis 1 or 2 inches into her vagina. That this is a very serious allegation, comes with a lot of exposure. Given the Act 3 element here, I would ask that you impose the state's recommended cash bail.
All right, and it would appear that Bennett has no prior criminal record.
Yes, that's my understanding.
All right, and Attorney Porter, your.
Well, the
position on that?
defendant's 50 years old and the public safety argument is absolutely ludicrous. This happened in May. It's a relationship issue. There's no indication that this man is preying upon women in the public, and he has had no contact with the victims in 90 days. So there's no indication that he's a threat to her. And I'm just shocked that the state would even propose such a preposterous amount of bail. But Mr. Diakite is a longtime resident of Madison. He's a celebrated musician in the community and public figure. He has not a lot of money. He works a menial job, but he makes a little bit of money from his music. There's no way that he could afford the $2,500, and he's 50 years old with no record. I don't think there's any basis at all for a cash bail.
All right, any response from the state?
No, Your Honor, I'd rest on my previous arguments.
All right, well, it's an Act 3 eligible offense. It's a serious charge. There's certainly the potential of prison if convicted. I don't know how that's gonna play out. It appears like it is a fairly strong case from the state's perspective, but obviously I have the state's version of events. It's significant to me that he's 50 years old and has absolutely no prior record. It's not somebody who's got a history of violating conditions of bail and things of that nature. I'm not satisfied that cash bail is necessary to protect the public. And I'm not satisfied that cash bail is necessary to assure his appearance here. He's retained counsel. Counsel asserts that if I were to order the state's requested cash bail, he may not be able to post that, unable to afford it. And this is not the type of case where we're essentially protecting the public by having confinement until the trial date. But it's significant that there's absolutely no prior record for somebody who's 50 years old. That leads me to believe that he's going to abide by all my bond conditions here and make his court dates. Can we get anything more descriptive as far as the victim, just as far as purposes of being able to enforce the bail conditions?
What initials work?
Yeah.
KSS.
All right, I'll order a signature bond. Condition will be a no contact director and direct with KSS. What about time limits for the?
We'll waive this time.
Okay, the clerk can let you know what we've got for a status date.
Yeah.
Right now, I'm looking at August 24th, 2:20.
I have a medical procedure that day.
We can do August 31st, 1:40.
I'm pretty sure that'll be okay. Let me just verify that. I'm sorry, what time?
1:40.
That'll work.
Okay, we are adjourned.
Thank you so much.
Thank you.
Next, get Phil.
Do you want to go to the food slot or do you want to stand? If you want to stand, you can.
Yeah, I understand.
That's fine.
Okay, we'll call the state of Wisconsin versus Avery Wampole, 26 CM 1811 appearances.
John Baik for the state.
Mr. Wampole, are you able to hear me? Can you give me a thumbs up if you're able to hear us? Okay, let the record show there was a thumbs up. Avery Wampole appears by Zoom in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint. We waive its formal reading. Mr. Wampole, would you still like the job center to be your address?
Yeah, because I didn't know my current address.
I wasn't able to hear that.
I didn't know my current address, so I just told them to send it to the job center.
Okay, we'll continue to use the job center as an address.
Yeah, that's fine for now. Thank you for clarifying.
And at this time, he is eligible for public defender services.
Oh,
Okay. We'll make a finding of probable cause and are not guilty pleas. There's a public safety assessment recommends moderate cash bail. State's position on bail.
State's requesting $300 cash bail with conditions that the defendant not possess or consume any alcohol and that he not direct any acts or threats of, or I'm sorry, display any act or threats of violence towards Nadia P, Nadia. Your Honor, it's my understanding that the defendant is familiar with that court system as evident by the misdemeanor bail jumping here. He does have a failure to appear last year, last October. Given this and the violation of bail conditions, we will be requesting some amount of cash to assure appearance in court.
Okay, and the defense position?
Your Honor, I do think that a signature bond would be appropriate here. I understand that there was a failure to appear last October, but I would say that he has a pretty good record outside of that. It seems like his prior failures to appear were the warrants were quashed, and it was because he was like unable to get to court. It looks like he has largely been able to appear for court. I would ask for a lower cash bail, if any.
All right. Let me just take a look at the underlying case. All right, well, the case that he's out on bail for, he's made all of his court dates as far as I can tell. If I'm missing a failure to appear in a warrant in 25 CM 2622, the state can point it out. So there appears to have been a track record of making all of his court dates since October, and he's had a fair number of them. It's not good that he's violating conditions of bail, such as consuming alcohol, but I also understand that that's a disease and that's something different than saying don't go to a particular area or have contact with a particular person. And the underlying charge ultimately is a disorderly conduct along with the bail jump. I'm gonna give him one more opportunity with a signature bond, order that you not possess or consume any alcohol. You direct no acts or threats of violence towards Nadia P. And will be adjourned.
Lopez is next, Edward Lopez. Edward Lopez.
Call the state of Wisconsin versus Edward Lopez, 26 CF 1682 appearances.
John Baik for the state.
Edward Lopez appears in person, in custody by counsel attorney Erica Becker-Brose. Erica Becker-Brose.
Erica Becker-Brose.
From the Public Defender's Office. He has received a copy of the complaint and we waive its formal reading. Is this the correct act?
¿Está correcta esta dirección, señor? Yes.
The address on the complaint is correct, and he is not eligible for public defender services.
Great, the bailiff's providing you the public defender info. If you're unable to retain an attorney after today, you could always reapply with them. We've got certified Spanish interpreter Jim Larson this afternoon. Mr. Larson, I'll swear you in for hearings at the jail. Do you swear or affirm that you will truly, accurately, completely, and impartially interpret the proceedings?
I do.
Right. We'll make a finding of probable cause, get not guilty pleas entered to the misdemeanors. And there's a PSA report that recommends a signature bond. What's the state's position on bail?
State's requesting $20,000 cash bail with conditions that the defendant surrender his passport and have no contact with any Lake Ridge Bank locations.
Wait Ridge Bank, Bank of Wait Ridge.
Your Honor, it's my understanding that Mr. Lopez lives in Chicago and has no ties to Wisconsin, other than being here with the intent to break into ATMs across Dane County. It's also my understanding that he's heavily involved of a ATM burglary group in Illinois. Here, he was possessing sophisticated tools and computers to break into ATM networks. I think given his involvement, as well as his lack of ties to the state, we would request significant cash bail.
And the defense position on bail?
Your Honor, I understand the concern about a flight risk. I would note that in the complaint, it is alleged that he states he cannot afford cash bail. I would be concerned that $20,000 is far beyond what is appropriate for a nonviolent crime. I also worry that surrender of a passport is inappropriate here. It is alleged he lives in Chicago, not that he lives in another country. I don't believe that a surrender of a passport is necessary, especially if there is already a cash bond.
All right. And does he have a passport?
¿Usted tiene pasaporte, señor?
He does not have a passport, Your Honor.
All right. Does the state have any information he has a passport?
No.
Pasaporte?
And I note it looks like there was an INS immigration hold that was dropped per the sheriff's protocols, but that might make sense that he wouldn't necessarily have a passport. He came here illegally, allegedly. It's concerning. He's got essentially no ties to the state of Wisconsin. He wasn't eligible for a public defender, so he must have some assets. He's alleged to be part of some broader criminal enterprise, and did appear to have some sophisticated electronic tools in order to break into an ATM. Has ties to another country. Looks like they had some contact with a vehicle with tags out of state that appear to be fraudulent. I think there's a risk that he's not going to appear, but it's a nonviolent property offense. There's no prior criminal convictions that I'm aware of based on the PSA. I'm going to set a much lesser cash bail. I'll set it at $5,000. I'll simply order, because I don't think I can hold him, but I'll order that he not use or possess a passport. He's saying he doesn't have one and the state has no information, so I'm not going to order the surrender of it, but if he has one and the state's able to prove that, that'd be a violation of the bail conditions. I'll order a no contact, direct or indirect, with Lake Ridge Bank locations, wherever they are located. And should we schedule a timely preliminary hearing in the next 10 days?
Yes, Your Honor.
Okay, and sir, again, if you can't hire an attorney, make sure you call the public defender's office. You can reapply, or they can point you in the right direction to apply for a county attorney. That next hearing is going to come up quite quickly. You'll need to go to the bailiffs and sign some paperwork, okay?
Entonces ahora vaya con ese señor para firmar su fianza. This way, sir.
All right, we will go on the record, the state of Wisconsin versus Arturo Herrera Rojas. It's 26 CM 1800 appearances.
John Baik for the state.
Arturo Herrera Rojas appears in person in custody by counsel Attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint. We waive its formal reading. So the address on the complaint is incorrect. I have a new address for you. That's 2219 Woodview Court. That's Madison 53713. At this time, he is not eligible for public defender services.
Okay, the deputy's going to hand you the public defender info. If you can't hire an attorney after today, you can reapply with them. Oh, I guess you already have it. We'll make findings of probable cause, get not guilty pleas entered to the charges. State's position on bail.
State's requesting $750 cash bail. Conditions that the defendant have no contact with Marlon O.S. Marlen. That he be banned from the 4600 block of Atticus Way. And that he not consume or possess any alcohol. Your Honor, here, this will be the defendant's fifth open case. He refuses to abide by bond conditions, specifically of not drinking or consuming any alcohol, and of course, following the law. He does have a failure to appear from last September that was served in October, about a month after it was, after the bench warrant went out. He also just had an initial appearance and was given a signature bond on July 27th. And in short order, allegedly commits this offense, or these offenses, I should say. Given that I believe that some cash bail is necessary.
Great, and the defense position?
Your Honor, I would ask for a lower cash bond. I would note that he has lived in Dane County for 2 years. He has a child who is 2 years old, as well as a spouse in this. He's also employed as a painter. I don't believe he's a flight risk, though I do understand that the previous failures to appear make the state nervous. I do believe less than $750 would be sufficient to ensure his appearance at court.
All right, well, it looks like in one of the underlying cases, there was a failure to appear in June. It's concerning that he continues to pick up cases. He's not following bond conditions. That concerns me about appearance risk. He's already out on $400 cash bail in 26 CM 322. At this point, I think it needs to be a higher amount than that. I'll set it at $600. Order no contact, direct or indirect with Marlon OS and a ban from the 4600 block of Atticus Way. And again, order that he not possess or consume any alcohol. And we'll be adjourned.
Gutierrez, next. There is mine.
So, Paul, the state of Wisconsin versus Mario Gutierrez Marum, 26 CF 1687 appearances.
John Baik for the state.
Mario Gutierrez Marim appears in person in custody by counsel attorney Eric Becker-Brose from the Public Defender's Office. He has received a copy of the complaint and we waive its formal reading. The address on the complaint is correct, and at this time, he is eligible for public defender services.
All right, so this looks like it's a reissued complaint from 26 CM 1756. And I think he's sitting on cash bail. There's also body only hold out of Jefferson County, it looks like. This was a late ad. I haven't had a chance to review the complaint, so I guess I'll hear the state's position on bail while I'm reviewing that.
Your Honor, the state is requesting $5,000 cash bail. Conditions that the defendant not use or possess any dangerous weapons, as that term is defined by statute. That he have no contact with Snader, A-M, M as in Mike. Snader is spelled S-N-A-Y-D-E-R. That he be banned from Snader A.M.'s residence, place of employment, or any area occupied by Snyder. Your Honor, in addition to the alleged facts in the original CM case, which led to the original cash bond, including the defendant providing a false identification and hiding evidence. He's now charged with serious felonies, including Act 3 eligible offenses. The state received, or it's my understanding, that the state received follow-up information indicating that Mr. Gutierrez was not simply acting in self-defense when the victim was injured as described in the original complaint. He faces much higher exposure now, possesses a higher risk of threat to the community. There's a serious need for protection of the public. So based on these factors, I would ask for significant cash bail. And I'll also move to dismiss 26 CM 1756.
Right, and the defense position on bail.
Your Honor, I understand the seriousness of these charges. I would point out that I'm not seeing a history of failures to appear for Mr. Gutierrez Marim.
Well, and I think we had him in court recently. I think
Yeah.
there are failures to appear, and I think there was at least a failure to appear in the Jefferson County case. That wasn't like a complaint warrant that went out, but I'd have to take a look at the records again. And I think it might have something to do with the spelling of the last.
Understood. Give me one moment. I'm not able to find that well, I am trying to find the case that you are referencing, Your Honor, but I would also note, he is eligible for public defender services. I understand a need to increase the cash bail that was given previously. I do think that $5,000 is a significant increase.
Yeah, and I think it might be Jefferson County case 25 CT 27.
It is.
Thank
The
you.
spelling difference is the last letter of the second last name. It's an N in the Jefferson County case. not an N.
Understood. Thank you. Okay.
All right, and any response from the state?
No, Your Honor.
All right, well, there is the failure to appear in the Jefferson County case. Cash bail is already found to be appropriate due to the obstructive behavior. We've now added on an Act 3 eligible offense. I think more significant cash bail is warranted here to assure appearance in court. I'll set $2,000 cash bail. Order a no contact direct or indirect with Snyder AM, their residence, place of employment, or any other place that they're temporarily occupying, and that they not use or possess dangerous weapons as that's defined by the state statutes. What about time limits for the preliminary hearing?
We'll keep the time limits, Your Honor.
Okay, we are adjourned.
Bruce, we got snacks. This way, so I think some.
We'll call the state of Wisconsin versus Eduardo Cruz Munoz, 26 CF 1677 appearances.
John Baik for the state.
Eduardo Cruz Munoz appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint and we waive its formal reading. The address on file is correct, and at this time, he is not eligible for public defender services.
All right, the deputies handing you the public defender info. If you're not able to retain an attorney after today, you can give them a call and they can point you in the right direction for a county attorney or reapply with their office. We'll make findings of probable cause, enter a not guilty plea to the misdemeanor. And there's a PSA reporter recommends a signature bond. What's the state's position on bail?
State is requesting a signature bond with the conditions that the defendant not direct any acts or threats of violence towards Jeanette XM, JEANETTE, and that he not consume or possess any alcohol.
No objections, Your Honor.
Okay, so we'll order a signature bond. Conditions will be that you direct no acts or threats of violence towards Jeanette XM and that you not possess or consume any alcohol. As to time limits for the preliminary hearing.
Give me one moment.
I'll get a train.
So. We'll keep the time limits, Your Honor.
Okay, we are adjourned.
You're on.
You're welcome.
Back to you, Bill.
I didn't catch the name.
You're on.
Tyler.
Kane, KEI.
All right, we'll call the state of Wisconsin versus Tyler Kime, 26 CF 1681 appearances.
John Baik for the state.
Tyler Kame appears by Zoom in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. Mr. Kame, if you can hear me, can you give me a thumbs up? Let the record show he gave a thumbs up. He has received a copy of the complaint and we waive its formal reading. Mr. Kame, is your address on Russet Road, correct?
Is it 5822 Russet Road?
Yes.
Yep, that is correct.
Okay. I have a new address for the court. That is 5822 Russet Road, Madison. That's 53711.
All right, thank you.
Oh, and at this time, he is eligible for public defender services.
We'll make findings of probable cause for the charges, get not guilty, pleas entered. There's a PSA report or recommends a signature bond. State's position on bail.
State's requesting $1,000 cash bail with conditions that the defendant be banned from the 2200 block of Woodview Court here in Madison, and that he not use or possess any dangerous weapons as defined by statute. Although it's the state's understanding that the defendant does not have any prior failures to appear, he was extremely resistive to law enforcement officers' attempts to take him into custody for this incident. It's alleged that he threatened suicide by cop and also threw or poured hot sauce on them. Given this behavior and some of the other behavior alleged in the criminal complaint, the state believes that cash bail is appropriate and necessary to ensure future appearance in court.
Right, and the defense position.
Your Honor, we would ask for a signature bond. I would note he has no prior failures to appear, although he has one prior case. Again, he has no failures to appear in that. I don't think that the facts of this case lead me to believe that his ability to appear in court has changed. I disagree that being allegedly resistive to cops means that he won't show up to court in the future. I would also note again that it's currently a nonviolent offense. He doesn't have any pending charges. He has no prior misdemeanor or felony convictions, and no prior failures to appear. He's lived in Wisconsin for 13 years. He has previously been employed here. He has a girlfriend here in the city. I don't think that is going to be an issue that he will continue to show up in court. I would just ask for a signature bond in this case.
All right, well, I think count 3 and perhaps count 1 are considered violent offenses under Act 3.
They are. Count 1 is and count 3 because of the answer.
Mhm.
All right, any response from the state?
Well, I suppose I didn't explicitly mention this, but they are actually eligible offenses. But I think the resistive behavior here demonstrates at least an inability to not comply with lawful commands, which then leads the state to believe that the defendant may not appear in future court proceedings.
Yeah, anytime somebody's resistive with law enforcement, it concerns me about whether they're gonna show up. The point of resisting law enforcement is to avoid the consequences, and now he's charged with a felony and other consequences here. And this wasn't really a minor resistive incident. I think some cash is warranted. I'm willing to set it at a lesser amount. I'll set $500 cash bail. Order a ban from the 2200 block of Woodview Court in order that he not use or possess any dangerous weapons as defined by the statutes. And is he going to want a prelim in the next 20 days?
Yes, Your Honor.
Okay, we'll get that scheduled and we'll be adjourned.
Ryberg is next, Tyler Ryberg. Ryberg.
We'll call the state of Wisconsin versus Tyler Ryberg, 26 CF 1679 appearances.
John Baik for the state.
Tyler Rayberg appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint and we waive its formal reading. The address on file is correct, and he is eligible for public defender services.
Great, we'll make findings on probable cause. And we'll get not guilty pleas entered. I think there may be a victim who wanted to make a statement, according to the notes that I have. If that's the case, that person, all right, it looks like the name is Cheyenne Hale, Cheyenne, like Cheyenne, Wyoming.
Yes.
All right, and what did you want to say about bail or bond conditions, Ms. Hale?
I just want to say that I would like no contact because I don't want them, I want them to have contact because we live together in the same house and these are his kids. And I'm just want to put this out there. He's struggled for the last couple months because his brother committed suicide in June, and before this, he had another court case for his OWI. He stopped drinking, but just recently started drinking because of his brother dying. But he is really trying to stop drinking, and I do think he does need to get help for his drinking problems. That's all I have to say.
And I just want to clarify, because when you first started speaking, I thought maybe you didn't want him to have contact with you, but then
I do.
I think you're saying you don't want the no contact to be ordered, is what you.
Yeah. Yes.
Got it. All right. Thank you, Ms. Hale. Attorney Baik, your position on bail.
State's requesting $500 cash bail with conditions that the defendant have no contact with child victim 1 or child victim 2. Defendant not use or, possess or consume any alcohol. And I'm not sure if there's still a waiting list, but that pretrial services be employed for alcohol monitoring. Your Honor, first and foremost, the defendant's on bail for an OWI, second offense with minor passenger in the vehicle. He has a specific bail condition not to drink any alcohol, yet he did so. It's alleged that his kids at around midnight are wandering around the neighborhood. Given this behavior with the open case and the flagrant violating of bail, we believe that some cash bail is necessary, as well as the no contact orders.
All right, and the defense position on bail.
Your Honor, first, I would like to note, I believe that in the complaint, it states that it was a little after noon rather than after midnight. So I just want to clarify that. We would ask for a signature bond here, as well as allowing contact with the child victims 1 and 2. I would note that he has no history of failures to appear. His criminal history, other than this open case, is pretty old. I have every reason to believe he'll be in court. I would note he's lived in Dane County for 8 years. He I think has every reason to come to court for these charges. It seems like he has had some personal hardship in his life recently with his brother dying, and that I think he's trying to get things right and get things back together. I would again point out that Ms. Hale would like contact and wants him to be able to be in the home with them. And I would ask that you take that into consideration.
All right, and can we get initials or something that's more descriptive, so any conditions I order can be enforced as opposed to victim 1 and victim 2?
Yes, I'll get that. Just give me one moment. But in the meantime, I would also note that it's my understanding that CPS are in support of the no contact order, or in support of a no contact order with the children. And frankly, do not believe or do not feel confident in his ability to care for the children at this moment. The initials are DKL and MLR, M as in Mike.
All right. Well, I don't know of any prior failure to appear history or any extensive prior criminal record other than the underlying OWI charge. I guess I'm not satisfied that cash bail is necessary to get Mr. Rehberg to appear in court. I don't believe the offenses are Act 3 eligible, and I'm not sure that there's a compelling Act 3 argument for cash bail in this case. I am going to order that he not possess or consume any alcohol. I am going to order the no contact. It sounds like that is what CPS's request is, but I'll allow contact as authorized through CPS. So if they think that you can have contact while they're present, or if they think that Ms. Hale is an appropriate supervisor or somebody else, great. I'm not trying to keep you from your kids. But it is a pretty concerning incident where what they allege is a 2 or 3-year-old ended up in a vehicle while you're allegedly passed out inside. Is concerning behavior. So we'll order no contact direct or indirect with MLR and DKL except as approved by Child Protective Services. And what about time limits for the preliminary hearings?
One moment.
Sure.
We'll waive the time limits, Your Honor.
Okay, we are adjourned. Thank you.
Watola, Tiger, Watola's next, yeah, Bill.
You're up.
Great, we'll call the state of Wisconsin versus Tiger Watola, 25 CM 3022 appearances.
John Baik for the state.
Mr. Watola, are you able to hear me? If you can give me a thumbs up. Mr. Watola, I have it noted that you don't want public defender representation. Would you still like me to represent you at this hearing today?
Yeah.
I think that's probably a good idea,
Okay.
given the posture of the case. So
Mhm.
this is a bail bond hearing. There was a failure to appear July 24th of this year, but competency has been raised.
Yes.
There's been an evaluation. Given competency is potentially an issue, I'm not comfortable letting Mr. Watola represent himself here today.
Absolutely.
Furthermore, I need to state that I didn't say that I wasn't wanting presentation. I said it to you that I didn't have any questions about anything.
Okay,
Okay,
thank you.
no problem.
All right, and are we still using the 225 South Morris Street address in Stoughton for Mr. Watola for mail?
Mr. Watola, is that Morris Street address good for you? Yes, Your Honor.
He said yes.
All right. And we should make sure that he gets the public defender info if he doesn't have an attorney at this point. Any information the defense wants to provide about the failure to appear on July 24th?
I would request a moment to speak with my client.
Okay, I think they can set you up in a breakout.
That'd be perfect. Thank you.
All right, take a brief recess unless we can do some forfeitures.
Mullins?
We'll call the County of Dane versus Jalen Mullins, 26 FO 1443 appearances.
John Baik for the county. Defendant appears in person in custody without counsel.
All right, and Mr. Mullins, the good news is you're not getting charged with a crime. They've charged you with county disorderly conduct. That's a non-criminal charge. It's the type of charge where they're gonna have an offer and we'll see what that is, okay?
County is offering court costs.
Okay, so if you wanted to accept that offer and enter a no contest or guilty plea, you'd have to pay $114.50 in the next 60 days or work out a payment plan with the clerk's office if you needed more time. Do you want to accept that offer or do you want to contest the charges?
Yeah, I'll accept it.
All right, I'll accept that as your no contest plea to the charge. Judge you guilty, or you pay court costs of $114.50. They're gonna give you the info about making the payments and you'll get processed and release you at some time today, okay?
Appreciate it. Thank you.
All right, you're welcome. We are adjourned. All right, I think we've got Mr. Watola back, so we're back in the record in 25 CM 3022, State of Wisconsin versus Tiger Watola. The appearances are as before. Attorney Becker-Brose, you've got information you want to provide about the failure to appear?
Yes, Your Honor. It seems like there was a miscommunication and thus he did not appear.
Okay, and what's the state's position on bail?
State's requesting $500 cash bail with all the previously stated non-monetary conditions. Your Honor, the defendant has quite an extensive, well, not too extensive, but several failures to appear in the past. Of course, this one was for July 27th. He also has one in June as well, June of last year, I'm sorry, as well as two from 2020. It's also apparent from the competency report, it's document 11, which was filed July 7th, that the doctor was unable to render an opinion. Multiple attempts were made to evaluate the defendant's current competence, but he failed to show up for an in-person examination on June 26th. He didn't sign in a video conferencing platform on July 2nd. This is on page 6 of that document. So that gives some concern for the state. to have the defendant evaluated for his competency as well as his appearance in court. So we would ask that you impose $500 cash bail.
Right, and any response?
Your Honor, I would simply ask for a lower cash bail.
All right, well, I think I would have the authority to order him taken into custody for an inpatient evaluation. I guess I'm not gonna do that. The state's not requesting that, but I certainly have concerns about whether he's gonna show up in court, given the non-compliance with the competency evaluation, the failure to appear here recently, another one just over a year ago, and then multiple within the last 6 years. So I'll set $500 cash bail with the prior non-monetary conditions, I guess. I don't know if this goes back to the same judge that was gonna hear the competency, if they get it once they've owned it, or it goes to the new duty judge, but the clerk will sort that out.
Yeah, I believe it'll go back to the branch that it was raised in the trial, right?
And
All
until you pay the fine.
We are adjourned then.
Good night, is next. Good night.
We'll call the state of Wisconsin versus Spencer McKnight. It's 26 CM 1816 appearances.
John Baik for the state.
Spencer McKnight appears in person in custody by counsel, Attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint and we waive its formal reading. The address on file is correct, and at this time, he is not eligible for public defender services.
Okay, so Mr. McKnight, the deputy is going to be handing you the public defender info. Obviously, you have the right to an attorney after today. If you can't hire one on your own, you can reapply with a public defender or apply for a county appointed attorney. I'll make findings of probable cause and are not guilty pleas to the charges. State's position on bail.
State's requesting a signature bond with conditions that the defendant have no contact with Kathy H.M., M as in Mike. Kathy is spelled C-A-T-H-Y. That the defendant be banned from the 6100 block of Century Avenue in Middleton. And finally, that he maintain absolute sobriety.
Any objections?
Your Honor, we have no objection to the signature bond. I would ask, my apologies. No objections, Your Honor.
Okay, we may need a updated mailing address if he agrees to those conditions.
Not necessarily the place I can say, but another mailing address might be 8101 Mayo Drive.
8101 Mayo Drive. And the zip code there.
Be sure on the zip code.
Okay, and are we gonna need to send that in care of somebody else's name for mail to get delivered? Okay. And you can always sign up for text message reminders to make sure you don't miss future court dates. If you need to get any items from the residents, you gotta coordinate that with the Middleton Police Department for what's called a preserved piece. Otherwise, don't go back there or have any contact with the victim. I'll order a signature bond. Condition will be a no contact direct or indirect with Kathy H.M., a ban from the 6100 block of Century Avenue. That you not use or possess any alcohol or use or possess controlled substances or any drug paraphernalia without a valid prescription. And we'll be adjourned.
That's great, sir. Neil is next. Neil. All right, we're here.
McNeil or Neil? Oh, Neil.
Neil.
Great, we'll call the state of Wisconsin versus Robin Neal Jr., 26 CM 1807 appearances.
John Baik for the state.
Robin Neal Jr. appears in person in custody by counsel, Attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint. We waive its formal reading. The address on file is correct, and he is eligible for public defender services.
I neglected to call one of the cases. They're both very similar. We've got 26 CM 1807 and 26 CM 1817. We'll make findings of probable cause for the charges, get not guilty pleas entered. State's position on bail in each of the cases.
State is requesting $500 cash bail on each case for a total of $1,000. On both cases, we are requesting that the defendant have no contact with Imani S. Imani, that he be banned from any place where Imani S is temporarily occupying. Your Honor, these are Act 3 eligible offenses. In the 1807 case, it's alleged that the victim is in a vehicle with the defendant where he punches the victim in the face over and over. In addition, it is a domestic relationship as they do have a child in common. The second case is somewhat similar. Defendant actually admits that he hit the victim, the same victim, to law enforcement, and the victim has an injury on her mouth. Given these two sort of back-to-back Act 3 eligible offenses, we believe that a significant amount of cash bail is necessary to ensure protection of the public.
Right, and is there a prior history other than these cases?
I am not aware of prior history in Dane County. Nor any other county.
Okay, and the defense position on bail?
Your Honor, we would ask for a signature bond or at most $500 for both cases combined. Your Honor, as noted, he has no criminal history at all, and thus I think there's no reason to think that he will fail to appear in court. He does have twins here, they're 1-year-old. With this family, he has parents, he has siblings, extended family and friends. I don't think there's any reason he would leave Dane County. I think he has every reason to stay here and be a part of this court case. Again, it's his first criminal case, both of them. I think that while there's a need to protect the alleged victim, I think that a no contact order does that sufficiently. I don't think that a large cash bond is necessary to do so. I think that he has every reason to continue coming to court, and that a no contact order would be sufficient to protect the public.
Okay, and any response from the state?
No, Your Honor, I rest on my previous argument.
All right, I see this differently than if he came in on case 1, was given conditions and then violated those conditions. It is concerning that he's got 2 instances of domestic violence. I'm not condoning that. But I have somebody who has no prior criminal record. I'm not persuaded the state's met their burden of proof that cash bail is necessary to get Mr. Neal to abide by any of these court orders. So I think he gets the benefit of a signature bond here with a lack of prior record. I'll order that in both cases. I will order a no contact direct or indirect with Imani S. In any other place that she's residing or temporarily occupying. If you need to get any items, you'd need to contact law enforcement. Make sure that you follow these conditions, Mr. Neal. It's probably going to be a pretty easy call that cash is necessary if there's violations of these conditions, and meaning I got the bail wrong. So hopefully you don't put yourself in that spot. All right. We are adjourned.
Garner is next, Xavier Garner.
Okay, we'll call the state of Wisconsin versus Xavier Garner. It's 26 CM 1813 and 26 CT 558 appearances.
John Baik for the state.
Xavier Garner appears in person in custody by counsel attorney Eric Becker-Brose from the Public Defender's Office. He has received a copy of the complaint. We waive its formal reading. I do have a new address for the court. That is 58 Northridge Terrace, thank you, number 103. And that zip code is 53704. And he is eligible for public defender services.
Right, we'll make findings of probable cause, get not guilty pleas entered in each of the cases. State's position on bail.
Your Honor, the state requests a signature bond with conditions that the defendant not operate a motor vehicle and that he not operate a motor vehicle without a functioning IID. Here, of course, he's charged with 2 separate OARs. It's also my understanding that he has 2 prior OAR convictions and 4 prior OWI convictions. Given that, we believe that these bail conditions are justified.
All right, and just to clarify, it's a signature bond for both of the cases, same conditions.
Yes, sorry, yep.
Yep, no problem. Any objections?
No objection to signature bond or conditions, Your Honor.
Okay, we'll order a signature bond. Conditions will be that you absolutely not operate a motor vehicle. And that you not operate any motor vehicle without a functioning ignition airlock device installed. And I don't know, maybe it's somewhat duplicative, but given the history, probably is appropriate to have the added protection, I guess. We will be adjourned.
Clevin will be next via Zoom.
You're up.
We'll go on the record in the state of Wisconsin versus Garrett Clevin, 26 CM 1815 occurrences.
John Baik for the state.
Garrett Clevin appears by Zoom in custody by counsel attorney Erica Becker-Brose for the Public Defender's Office. Mr. Clevin, are you able to hear me okay? Can you give me a thumbs up? Okay, he did get a thumbs up. He has received a copy of the complaint and we waive its formal reading. Mr. Clevin, is the address on Torino Court accurate for you? Is that still a good address? Sorry.
That's correct.
I'm not.
He said yes.
Okay, the address on file is correct, and he is eligible for public defender services.
Okay, we'll make a finding of probable cause, enter a not guilty plea to the charge. State's position on bail.
State's requesting a signature bond with conditions that the defendant be banned from Fitch-Rona Road. That's in Fitchburg, that he have no contact with Ronald S. or any member of his family.
Any objections?
I have no objection to the signature bond. I would have an objection to the ban from the entire Fitch-Rona Road. I wonder if there would be a more specific address for that.
All right, any response from the state?
Sorry, just one moment.
I think they're alleging the 2600 block of Fitch-Rona Road was where the incident occurred, but.
So my understanding, Your Honor, is that Fitch-Rona Road is not a thoroughfare. It's also my understanding that the defendant lives in Middleton and so would have no reason to be there. I think with the charges as alleged and the complaint and the facts alleged, it's a rather scary situation here. It is a standalone disorderly conduct, but I do think that full address ban is justified.
Right. And any additional response?
I would just add Fitch-Rona Road is quite a long road. It is a way to cut across from, I believe it's 151 to Highway 18. I again would request a much smaller area that is banned. I think that that's a very large area that can be used for legitimate reasons.
All right. I guess I don't know that there's a need for a ban from the entirety of Fitch-Rona Road, but I'm gonna order a ban from the 2000 to 3000 block of Fitch-Rona Road, which should fully encompass the 2600 block. That's still probably a fairly large chunk that he cannot be on. And he's gonna have to pay close attention if he's using Fitch-Rona Road, that he's not violating these conditions. Otherwise, he can be arrested and charged with bail jumping, and potentially the state will ask for cash bail. I will also order no contact direct from direct with Ronald S. or any of Ronald S.'s immediate family members as the other condition of his signature bond will be adjourned.
The Dow is next. Mr. No, Andrew. Andrew.
We will call the state of Wisconsin versus Andrew Sydow, 26 CM 1674 and 26 CM 1810 appearances.
John Baik for the state.
Andrew Cito appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint. We waive the formal reading. The address on file is correct, and he is not eligible for public defender services at this time.
All right, sure, the deputy's handing the public defender info, give them a call if you're not able to hire an attorney after today. You can reapply with them or apply for a county attorney. We'll make findings of probable cause. Get not guilty pleas entered to the charges. And I think there's a PSA report, recommends cash bail. What's the state's position on bail?
State is requesting signature bonds on both cases, with conditions that the defendant have no contact with Brittany K, BRITTANY, also in both cases.
Right, any objections?
No objections, Your Honor.
Okay, I'll order signature bonds in each of the cases, order no contact direct or indirect with Brittany K. You want to make sure that you're following that. The public safety assessment suggested that maybe some cash was appropriate here. I'm not ordering that, but if we're back here for violations of those conditions, that might well be appropriate at that point. We are adjourned.
Camp Sheriff's next, Sasha Camp Sheriff. You know. Alright.
I think that's our forfeiture.
You wanna see down through the food slot? It's actually.
We'll go on the record in the County of Dane versus Sasha Campshire. It's 26 FO 1440 appearances.
John Baik for the county. Defendant appears via Zoom in custody without counsel.
All right, and Ms. Campshire, the good news is they've decided to charge you with a non-criminal offense for county disorderly conduct, even though you got arrested for criminal charges. And this is the type of case where they'll have an offer, so we'll see what that is, okay? Oh, sorry, Mr. And Attorney Baik, what's the offer?
Offers for court costs.
All right, so if you wanted to accept that offer, you'd have to pay court costs of $114.50 in the next 60 days, or work out a payment plan with the clerk's office if you need more time. Did you want to accept that offer? Or do you want to contest the charges?
Can I say non-guilty at this point and have a second conference? Because
Yeah.
I need some time to I've been in here, I've been in this cell and I just need to get out of it.
They usually keep that offer open till the pretrial. So if we enter a not guilty plea, you'll get released. And then if you want to accept that offer, you can let them know by the pretrial. Otherwise, they may withdraw that offer. It's not accepted by them.
Okay.
Is the 734 O'Dana Lane address in Madison still a good place for mail?
I was in the process of moving. So when I get out of here, I'm moving out. So can I give you an address where I can accept mail?
Yeah.
Yeah, 7412 Elmwood Avenue, Middleton, 53562.
Okay. And I do need to advise you that if you want to preserve your right to a 6-person jury trial, instead of just having the judge hear the evidence and determine whether you committed the offense, you need to make a written demand within 10 days of today's date and post $36 of non-refundable jury fees to the clerk of courts. And we'll be adjourned.
Thank you.
Yep, you're welcome.
Jacob, Carissa. Jacob. And.
Great, we'll go on the record in the state of Wisconsin versus Carissa Shaper. It's 26 CF 1683 and 26 CF 1685 appearances.
John Baik for the state.
Carissa Shaper appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. She has received a copy of the complaint and we waive its formal reading. The address on file, I would give you the job center at 1819 Aberg. And she is eligible for public defender services.
Great. I'll make findings of probable cause for the charges. Looks like 26 CF 1683 is a reissued complaint from 26 CM 1412. And we'll address bail. What's the state's position on bail?
State's requesting $500 cash bail in each case for a total of $1,000. In both cases, the non-monetary condition request from the state is a ban from the state in Langdon area per the ban map. Your Honor, it's concerning that there are two sort of different instances of resisting causing injury to an officer. In the second case, the 26 CF 1685 case, she's also violating a very specific bond condition not to be in State Street or in the 400 block of State Street. Yet she's doing so and then resisting and then causing injury to the officer. Given all of these elements, the state believes that some cash bail is necessary to ensure appearance.
Right, and the defense position?
Your Honor, I would ask for either a signature bond or a very low cash bail. I do think that $1,000 total is very significant considering the allegations. I would note that she's eligible for public defender services, so she is indigent. $1,000 is well beyond her ability to pay for bail here. She also has a child. She has some marks from the cops. It seems like this was quite a encounter in which she also I think she has some significant complaints about the treatment during these cases as well. I think that making her stay in jail during this is not necessary.
All right. Well, all the facts are gonna play out on another date if Ms. Schaefer exercises her right to a trial. It is concerning though that she's got not one but two cases. She did get a signature bond and it was charged out as a lesser offense misdemeanor. That's to her credit, but then we come back in short order with another one and violating specific conditions of bond. So you're not showing yourself to be a good bail risk if you're going to places that you promised when you sign your bond that you're not going to be. So I do agree with the state. Some cash is necessary. I'll set it at $250 in each case. And again, order you can't be in the State Street Langdon area per the band map. All the cops know who's not supposed to be there. So you go back there, you're probably going to be arrested in short order, and then the state will be filing additional charges and asking for higher amounts of bail. So don't put yourself in that situation. What about time limits?
I'm sorry. Can I ask a clarifying question? Was it a ban from this entire area or just the 400 block of State Street?
Entire area.
The entire area. Okay. Give me one moment.
Your Honor, if the CM case is open, I'd also move to dismiss that case. I believe it is.
Hopefully is. Let me.
And I wasn't. We're going to keep the time limits, Your Honor.
Sounds good. And it does look like it's still pending, so we'll get that dismissed. It looks like the judge is monitoring that to see if a motion to dismiss was filed. So we'll take care of that. And I think there was also another court date on August 6th that can probably be canceled then. We are adjourned.
I don't. So I have to get $500 to go out. It's like this, so you marks of the and they call it claim versus state. That's.
You can have your lawyer file a bail motion if you're not able to post the bail this shape.
Sorry, who was next?
I don't know, actually.
Okay.
Sorry, who do we have?
Webster.
Okay, we'll call the state of Wisconsin versus Kathleen Webster, 26 CF 1686 appearances.
John Baik for the state.
Kathleen Webster appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. She has received a copy of the complaint and we waive its formal reading. The address on the complaint is The address on the complaint is correct, and she is eligible for public defender services.
Great, I'll make findings of probable cause, enter a not guilty plea to the misdemeanors. The PSA report recommends cash bail. State's position on bail.
State's requesting $300 cash bail, condition that the defendant not consume or possess any controlled substances or drug paraphernalia without a valid prescription. Your Honor, it's my understanding that the defendant has 3 open cases here in Dane County. Also posted a total of $250 in those cases, or across those cases. Given the non-compliance with the very general bond condition of not committing any new crimes, we would ask for that cash bail.
Great, and the defense position.
Your Honor, I would ask for the 250 that she was able to post the prior times. I don't think that an increase would be necessary.
All right, does the state know anything about the warrants that she allegedly had according to the complaint? So I think she's sitting on body only warrants in multiple felony cases. Given that and the continued violations of the general condition of bail not to pick up any new charges and having posted the cash bail, I think the state's request is pretty well warranted at this point. Probably a moot point because you're going to have to address the body only warrants with the judges. I'll set $300 cash bail, order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. And as to time limits.
We'll keep the time limits, Your Honor.
Okay, we are adjourned.
Paul Claire's next, maybe.
On the record in the state of Wisconsin versus Mindy Hosler, it's 26 CM 1819 appearances.
John Baik from the state.
Mindy Hosler appears in person in custody by counsel attorney Eric Becker-Brose from the Public Defender's Office. She has received a copy of the complaint and we waive its formal reading. The address on file is correct and she is eligible for public defender services.
Okay, I'll make a finding of probable cause. She might be serving out a sentence. It's not entirely clear.
That is correct.
What's the state's position on bail?
State's requesting a signature bond with the sole condition that the defendant not possess any or use any form of identification unless it is issued in her full legal name.
No objection, Your Honor.
Okay, we'll order a signature bond. Condition will be that you not use or possess any identifying information that's not lawfully in your legal name. And we'll be adjourned.
Thank you. But Ronald's next.
All the state of Wisconsin versus Sarah Catrano, it's 26 CM 1814 appearances.
John Baik for the state.
Sarah Catrano appears in person in custody by counsel attorney Eric Becker-Brose from the Public Defender's Office. She has received a copy of the complaint. We waive its formal reading. I have a different address for you. I have 925 Owen Street, which is in Lake Mills, zip code 53551. And at this time, she is eligible for public defender services.
Okay, I'll make findings of probable cause and are not guilty pleas to the charges. State's position on bail.
State's requesting $300 cash bail with the condition that the defendant be banned from all Home Depot stores or locations in Dane County. Your Honor, it's my understanding that she has an open case here in Dane County. She posted $350 in that case. So it's concerning that she would go out and commit a new offense, at least allegedly. So we'd be asking for $500.
Great. Any defense position on bail?
Yes, Your Honor, we would ask for a signature bond. I don't see a history of failures to appear. I understand that she does have the bond in the other cases, but again, no issues with failures to appear here. This is a nonviolent offense. She's lived in Wisconsin all of her life. She has 2 children that live with her. She also has parents, siblings, extended family, and friends. I think that there's every reason to think that she will continue to. We would ask for a signature bond.
All right, taking a look at the underlying case 26 CM 1668, where she posted the cash bail. The PSA had her at a 6 out of 6 on new criminal activity, 5 out of 6 on failure to appear, noted at the time of that initial appearance, 2 or more failures to appear. So after having posted cash bail in relative short order, she's here with new criminal charges. I think the state's request is warranted. I'll set $500 cash bail, order a ban from all Home Depot stores in Dane County, and we'll be adjourned.
Jones, Jones.
We'll call the state of Wisconsin versus Carlicia Jones, 26 CM 1802 appearances.
John Baik for the state.
Carlicia Jones appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. She has received a copy of the complaint and we waive its formal reading. The address on file is correct and she does qualify for public defender services.
Great, I'll make findings of probable cause. We'll get not guilty pleas entered. State's position on bail.
State's requesting a signature bond with the condition that the defendant be banned from the J.C. Penney location at Easttown Mall here in Madison.
Any objections?
No objections, Your Honor.
Okay, we'll order a signature bond. The condition will be that you be banned from the J.C. Penney located at the Easttown Mall in Madison, and we'll be adjourned.
McNeil is next. McNeil.
Great, we'll go on the record in the state of Wisconsin versus Sean Treese McNeil. It's 26 CM 1805 appearances.
John Baik for the state.
Sean Treese McNeil appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. She has received a copy of the complaint and we waive its formal reading. The address on file is correct and she does qualify for public defender services.
Right, I'll make findings of probable cause, enter not guilty pleas. The PSA recommends cash bail. What's the state's position on bail?
State's requesting $500 cash bail with conditions that the defendant be banned from the UW Health Kidney Clinic on Fish Hatchery Road. That he have no contact, I'm sorry, that she have no contact with Lucille M as in Mike, Lucille spelled Lucille. No contact with Tiffany P, that the defendant not use or consume or possess any alcohol. Your Honor, it's my understanding that the defendant is out on a signature bond in her open case 26 CM 1014. Although I don't have any knowledge of any missed court appearances, I do think cash is appropriate given the misdemeanor bail jumping charge.
Right, and the defense position on bail?
Your Honor, I would ask for a signature bond. I would again reiterate that she has no failures to appear and she does not have a significant criminal history. Again, the one open case she has a signature bond in. I think that a ban from the UW Health Kidney Clinic on Fish Hatchery would be sufficient to protect the public and would address any concerns. I don't think that there's any reason to believe that she wouldn't show up in court, given her lack of history of failures to appear. She's lived in Wisconsin her entire life. She has parents and siblings here. So I don't think there's going to be an issue with her appearing in court.
All right. I agree with the defense. The PSA report suggests that she's never missed court at all. I'm somewhat perplexed as to how the 4-2 on the public safety assessment recommends cash bail without any step 2 or step 4 increase. It mystifies me, but it's not going to make a difference in my decision. I think with a lack of prior criminal record other than the one pending case, a signature bond is still appropriate to assure appearance in court. I'll order that. I'll order a ban from the UW Health Kidney Clinic on Fish Hatchery Road. No contact director and director with Lucille M. and Tiffany P. and that you not possess or consume any alcohol. You keep picking up cases, though, that analysis can change. So make sure that you make your court dates and follow your bond and don't pick up any new cases, okay? We are adjourned.
This one fair is next, fair, forfeiture.
All right, we'll call the County of Dane versus, right in front of the podium, there's fine. Tonchile Fair, 26 FO 1441 appearances.
John Baik for the county. Defendant appears in person in custody without counsel.
All right, so you got arrested for criminal charges. They decided to not charge you with any criminal charges. You got charged with forfeiture offense, county disorderly conduct. So it's more like a speeding ticket. It's the type of case that they're going to have an offer. So we'll see what that is, okay?
Court costs.
Right, if you wanted to accept that and enter a no contest or guilty plea to the charge, pay $114.50 in the next 60 days, or work out a payment plan with the clerk's office. The matter would be resolved. If you want to contest that, you can enter a not guilty plea. How do you wish to proceed?
Not guilty.
Not guilty? All right, we'll enter the not guilty plea. I do need to advise you that if you want to preserve your right to a 6-person jury trial, instead of having a judge hear the evidence, you got to make a written demand within 10 days of today's date. Post $36 in non-refundable jury fees to the clerk of court's office. We've got 809 Brandy Road in Madison. Is that still a good mailing address?
It's 804.
804 Brandy Road. All right. We'll be adjourned then.
Thank you.
This one. Randall is next.
Great. We'll call the state of Wisconsin versus Dylan Randall as 26 CM 1808 appearances.
John Baik for the state.
Dylan Randall appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint and we waive its formal reading. The address on file is correct and he does qualify for public defender services.
Okay. I'll make a finding of probable cause. Enter not guilty plea, state's position on bail.
State would request $250 cash bail with the condition that the defendant be banned from the UW campus. Your Honor, it's my understanding that the defendant was released a couple days ago, July 31st, the signature bond and a ban from the UW campus. Here, allegedly, the defendant's throwing chairs in Union South. He's mildly resistive. Based on these factors, we believe that some cash bail is appropriate.
Right, and the defense position on bail.
Your Honor, we would ask for a signature bond. I'd note that bail should be imposed based on the necessity to ensure his appearance in court. I don't think that there's been shown anything that he will not appear in court. I don't think that anything has changed such that a signature bond is no longer appropriate. I don't think that cash is going to change. I think he'll appear in court regardless, so I don't think that any cash is necessary here.
All right, well, like quick search on CCAP suggests this is the entirety of what he's got, at least in Dane County. I haven't done a wider search. Is the state aware of any prior
No.
history beyond these two cases?
No.
All right, well, when you're not following conditions of bail and violating specific conditions, when you make a promise that you're going to avoid those areas, I start to get a little concerned about whether you're going to follow other orders. I think it's a close call. I don't fault the state for asking for cash bail. I'm gonna give you one last opportunity on a signature bond. But you gotta abide by your conditions of bail. And I'll again order a ban from the UW campus. We'll get you another copy of the ban map. We probably previously provided that. And law enforcement is a pretty good idea who's not supposed to be in particular areas, when we've got these maps here. So, don't put yourself at risk of getting arrested with more bail jumping charges, okay? We are adjourned.
Take this way, sir. Moving to Webster next, Benjamin Webster, bail bond. Moving to Webster. Webster.
Right, we'll call the state of Wisconsin versus Benjamin Webster, 26 CF 982 appearance.
John Baik for the state.
Benjamin Webster appears in person by counsel attorney Erica Becker-Brose from the Public Defender's Office.
Great, so we should make sure we got a good address still for Mr. Webster. I think we got 4953 Mineral Point Road, Apartment 3 in Madison. Looks like he still has public defender attorney Anderson, and there was a failure to appear on June 29th. Any information you want to provide about that failure to appear?
Really quick, I believe that the address should be 4953, and it looks like on the complaint it's 4933.
We have 495.
Okay.
Mineral Point Road, apartment 353705, is that correct? Nancy?
Thank you.
Yeah, I think it got updated at the original initial appearance.
Okay, thank you.
But always good to check.
Your Honor, it looks like they were trying to reschedule the hearing, and it just wasn't able to get finished in time.
Okay, what's the state's position on bail?
Your Honor, I'd ask for $500 cash bail with the prior non-monetary conditions. It's my understanding that the defendant didn't show up for his out of custody initial appearance back in May of 2026. He was in custody for his initial appearance after a bench warrant was issued later that month. We have another situation where he was supposed to show up at a status conference, but did not do so. It's also my understanding that he does have a bench warrant. I believe it was from Dane County in December of 2023. Based on the history of failures to appear, I believe some cash bail is necessary.
Any response?
Your Honor, I would ask again for a signature bond and give him another chance, but if you would like to do cash bond, I would ask for less than what the state has asked for. I would note he is eligible for public defender services, and this is more than he would be able to pay.
All right, I'm concerned, given the history, this isn't just a one-off incident. I think some cash is necessary. I'm willing to set it a little bit less. I'll set it at $300 with the prior non-monetary conditions. Should we schedule it for another status conference, or does he want to get it scheduled for a preliminary hearing?
Your Honor, we'll do a preliminary hearing instead of a status. He has been assigned a public defender.
Okay, and that makes sense, because he maybe can't post the cash bail, so we'll get it set within 20 days if that's possible, and we'll be adjourned.
Silver is next, forfeiture.
Yeah, and he can always have his lawyer file a motion to modify the bail too, so give them a call.
Silver.
Forfeiture.
So.
All right, we'll call the County of Dane versus Anthony Silva. It's 26 FO 1444 appearances.
John Baik for the county.
Right, and Mr. Silva's in custody in person without counsel. Mr. Silva, the good news is you're not getting charged with a crime here. You're getting charged with county possession of drug paraphernalia. Bad news is there's a hold in Washington County. I can't do anything about that.
I understand.
But this charge, because it's a non-criminal charge, is the type of charge where they're gonna have an offer and we can see if you can resolve it, okay? So
All right,
we'll see what
sounds
the
good.
offer is.
Costs.
Okay, well, if you wanted to accept that and enter a no contest or guilty plea, you have to pay $114.50 in the next 60 days or work out a payment plan with the clerk's office if you need it.
No contest.
Okay, I'll judge you guilty based upon the no contest plea. Already paid a court cost of $114.50. They're gonna give you the info about making the payments and since it's a body only warrant, you can't post on that. You'll probably have to be taken back to Washington County. I assume that'll
Understood.
happen in the next day or so and then you
Understood.
can address bail there. All right?
All right.
We are adjourned.
Thank you.
And this next.
Great. Go on the record in the state of Wisconsin versus Marquise Sims, 26 CF 1684 appearances.
John Baik for the state.
Marquise Sims appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint and we waive its formal reading. The address on file is correct and he qualifies for public defender services. At this time, I do have reason to doubt his competency to proceed and I request a competency evaluation.
Okay. And under local court rule, and actually I think some case law suggests we should still be addressing bail. I'll make a finding of probable cause for the charges, get a not guilty plea, entered to the misdemeanor. And what's the state's position on bail?
State's requesting a signature bond with the condition that the defendant not operate a motor vehicle not registered in his own name.
All right.
No objections.
Okay, so we're gonna order a signature bond. Condition will be that you not operate a motor vehicle that's not registered lawfully in your own name. And then based upon counsel's representations, I'll find a basis to doubt competency. We'll suspend the proceedings at this point, and they're gonna get a hold of you. I don't know if there's a phone number we could take down to put on the paperwork to assist in meeting with the evaluator.
608
338.
338 3301.
Okay, and we'll be adjourned.
Okay, this way, sir. Right, this next, right. Right.
Wait, so go on the record in the state of Wisconsin versus Jaden Wright. It's 26 CM 1818 appearances.
John Baik for the state.
Jaden Wright appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint. We waive its formal reading. The address on file is correct and he does qualify for public defender services.
All right, I'll make findings of probable cause and are not guilty pleas to both counts. State's position on bail.
State's requesting a signature bond with conditions that the defendant have no contact with Michael E. and that he be banned from the 2300 block of Allied Drive.
Any objections?
Your Honor, we have no objection to the signature bond or the no contact order, but I would request that I apologize. Rather than a no contact order, I would ask for no acts or threats of violence so that he can still go to the address on 2300 Allied Drive as that is where he lives.
Okay, and any response from the state?
Your Honor, while this was not charged as a domestic violence enhancer, one was referred and the victim elected to enforce the 72-hour no contact. I think even with that and what's alleged in the facts, a no contact order is justified.
And anything else from the defense?
No, Your Honor.
Yeah, I mean, I think the victim could easily get a temporary restraining order. It'd have to be granted if they put any of the facts that are contained in this criminal complaint. And get a kick-out order from the residents. Their wishes were that there be no contact. That's the most recent thing I know. I think it makes sense now. Is there someplace else that you could get mail for the time being? Okay. All right, well, while you're chatting, I'll order the signature bond, the no contact director and direct with Michael E. and a band from the 2300 block of Allied Drive. If you need to get any items from the residents, you can contact law enforcement to do what's called a preserve the peace. Otherwise, don't be there or have any contact with the victim. Was there someplace else where we might be able to send mail? And if not, I believe he's going to get his next court date yet today. But make sure you're updating the public defender so they can update the court, and you could also sign up for text message reminders. Okay, right, we are adjourned.
Okay, this way, sir. Kristen is next. Trevor.
Call the state of Wisconsin versus Trevor Christian is 26 CF 1676 appearances.
John Baik for the state.
Trevor Christian appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He's received a copy of the complaint. We waive its formal reading. The address on file is correct, and he does qualify for public defender services.
Right, I'll make findings of probable cause for the charges that apply to this defendant and are not guilty plea to the misdemeanor. State's position on bail.
State's requesting $1,000 cash bail with conditions that the defendant. Sorry, 1 second. The defendant have no contact with his co-defendant, Megan Gibney. Your Honor, it's my understanding that the defendant is on federal probation, at least at the time of this offense. Of course, it's alleged that he fled from law enforcement, that he made a false police report, lied to officers, and then also encouraged other people to lie. That's certainly not behavior that's indicative of someone who would voluntarily show up to court absent a financial incentive to do so. So based on that, we would ask for $1,000 cash bond.
And the defense position on bail.
Your Honor, we would ask for a signature bond. I understand the concerns of the prosecution, but I would note that he is receiving some treatment. Okay, so he's receiving some treatment, and I think it's important to ensure that he can still get to his treatments rather than sitting in jail and being not able to do that. I understand again the concerns, but I would ask for a signature bond in this case.
All right. So the complaint says he just got out of prison and alleges that's the reason that he fled from law enforcement. The fleeing, eluding behavior is extremely concerning because it's putting your life at risk when you engage in that behavior. And I'm not trying to get you to comment about any of the facts. That'll be for some other day. But these charges are, to me, not consistent with somebody who's going to voluntarily show up in court. And I think some cash bail is necessary and appropriate. I'm not trying to put the kibosh in any of the treatment that you are getting lined up or in the process of getting, but I think there's a need for cash bail. I think the state's request is pretty well warranted. This obviously isn't your first time having the cops stop you. You know what was supposed to be done. I'll set $1,000 cash bail. Yes, was there an objection to the no contact with Ms. Gibney, the co-defendant?
Yeah.
One moment, sir. Yeah, we would object to the no contact order with Ms. Gibney, Your Honor.
All right. Any response from the state?
I think it's a little difficult to respond without a reason for the objection, but essentially the no contact order was requested because I think in the state's mind, Ms. Gibney contributed to the overall criminal conduct in this incident.
All right, and what's the need to have contact with Ms. Gibney? Is there some sort of relationship?
Yeah, he's been there, guys.
They've been dating for years, Your Honor.
All right. I guess I'm not persuaded that their contact together is what caused Mr. Christian to take off, more his fears of having been released from prison and gonna get in trouble. I get the concerns over both of them being witnesses against one another, but this is also somewhat dated at this particular point in time. That ship has probably sailed at this point. I'm not gonna order the no contact. I am gonna order that you not operate a motor vehicle without a valid driver's license, in addition to $1,000 cash bail. What about time limits for a preliminary hearing?
One moment, Your Honor. We'll keep the time limits, Your Honor.
Okay, we are adjourned.
Cross-Simmons is next.
I'm gonna go get it paid.
Yeah. They'll deal with that for you.
That's why I think you are.
You're welcome.
No.
We'll call the state of Wisconsin versus JAMAL KHIRY-KRAUSE-SIMMONS. It's 26 CM 1803 and 26 CM 1804 appearances.
John Baik for the state.
Jamal KHIRY-KRAUSE-SIMMONS appears in person in custody by counsel attorney Erica Becker-Brose from the Public Defender's Office. He has received a copy of the complaint. We waive its formal reading. It looks like to me that you have the Smithfield address on file. Is that correct? I do have a different address for mailing purposes, which is 224 S Bird Street, number 4, Sun Prairie. And that zip is 53590, and that's just for mailing purposes.
Okay,
And at this time, he is not eligible for public defender services.
all right. So Mr. KRAUSE-SIMMONS, they're going to give you the public defender info. You can give them a call if you're not able to hire an attorney on your own and get reevaluated or apply for a county attorney. We'll make findings of probable cause for the charges and are not guilty pleas. What's the state's position on bail in each of the cases?
State's requesting $500 in the 1803 case, $1,500 in the 1804 case, so that's a total of $2,000 cash bail. Both cases that the defendant have no contact with Zaira C, ZARIYA, that he be banned from the 200 block of South Bird Street in Sun Prairie, and that he not consume or possess any alcohol. Your Honor, I believe this makes cases 7 and 8. Yes, so he has 8 pending cases with these 2 new cases. They're all for bail jumping, violating very specific conditions of his bond. In 3 of those previous cases, which are all domestics involving this victim. He also does have failures to appear in April of 2023. He also has quite a significant amount of cash bail posted, a little north of $1,000. It looks like about $1,200. He's still violating very specific conditions of bond. We believe that significant cash bond is appropriate at this point.
And the defense position?
Your Honor, I would ask for a signature bond or in the alternative, $400 at most total, as that's what I believe the bond is in one of his other cases. I understand the concern with the pending cases. I I would note that the failures to appear were 3 years ago. It doesn't seem that he's had issues in these current cases with failing to appear. I would note he's about to start a new job. Being able to go to that job would be very helpful for him, keep him connected to the community, help him, I think that gives him even more reason to appear in court, being employed, having a reason to continue showing up. I just would ask that you take those into consideration.
All right, well, I don't want to see Mr. Krause-Simmons miss out on an employment opportunity, but I got to address bail and do what's appropriate. You've been in front of me. It wasn't that long ago. I set more than $400 cash bail. I think that got reduced by the judge, according to the records, from $750. There's just been repeated violation of specific conditions of bail. The state's request, I think, is pretty much warranted. It's essentially $1,000 in each of the cases. I'm going to order that because you're not a better bail risk than you were when I thought it was $750. So I'll set $1,000 in each case. I'll order a no contact direct or indirect with Zaharisi, the victim. I'm not sure that I pronounced that correctly. C, and then a ban from the 200 block of South Bird Street and that you not possess or consume any alcohol. And we'll be adjourned.
Ray, can I just confirm with you that I spelled that name correctly?
Same in the case.
Oh, thank you.
Next is Tugby Solora.
Go on the record in the state of Wisconsin versus Tugby Solura, 26 CF 1680 appearances.
John Baik for the state.
Tube Sulure appears in person in custody by counsel attorney Eric Becker-Brose from the Public Defender's Office. He's received a copy of the complaint. We waive its formal reading. The address on file is correct, and he is eligible for public defender services.
Right, I'll make a finding of probable cause. We'll get a not guilty plea entered to the misdemeanor. The PSA report recommends a signature bond. What's the state's position on bail?
State's requesting $750 cash bail with the condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. Your Honor, the defendant's on felony bond in 2 cases here. He's on one of them, at least one of them, on a specific condition not to use or possess any controlled substances, the same condition that I just recommended. He's also out on a total of $1,300 cash across those 2 cases. Although he has no history of missed court, given the fact that he's out on cash in these 2 cases and now allegedly committing another offense by possessing illegally obtained prescription, we believe that cash bail in the amount of $750 is entirely justified.
Those position on bail.
Your Honor, I would ask that you give a signature bond in this case, as noted by the public safety assessment. I don't think is a risk for missing court. He has no missed appearances at this point. Bail for a nonviolent offense should be set at the amount necessary to ensure his appearance in court. I think he's shown that he will appear in court. I don't think anything has changed from that. I would simply ask that the PSA report be followed and a signature bond be given.
All right, well, I agree, bail should be set in the amount that's necessary to assure appearance in court. It should be the least amount. I think a lesser amount of cash bail is sufficient, but I'm not satisfied that a signature bond's appropriate. He's out on cash bail in a couple of cases, continuing to pick up cases, in one case violating specific conditions of bail. He's not becoming a better bail risk in the eyes of the court by continuing to pick up cases. That said, the nature of this charge, I think, is more along the lines in 26 CF 619, where he had a $300 cash bail. That's been sufficient to get him to court. I think 300 is sufficient here. I'll order that. I'll order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. He would have the right to a preliminary hearing in 20 days.
Okay. So we'll waive the time limits, Your Honor.
Okay, we are adjourned.
Holden is next, forfeiture.
That might be your last case. I think you're good to go. This one's the forfeiture. Which one?
Holden,
No, Abubakar Diabate.
I think they posted or were released or something.
Oh, okay.
No,
I don't have
the-
him on my list.
Yeah, I think he posted or released.
Thank you so much.
He was on the calendar at some point. But taken off. We'll call the County of Dane versus Stephen Houghton, 26 FO 1442 appearances.
John Baik for the county defendant appears in person in custody without counsel.
Right, and Mr. Houghton, even though you got arrested for some criminal charges, they decided to charge you with a non-criminal county disorderly conduct. So that's not gonna keep you in custody any longer. It's the type of case they're gonna have an offer, so we'll see what that is, okay?
Pardon me?
It's the type of case where they're gonna have an offer. It's more like a traffic ticket, so they're gonna make an offer to resolve it. If you
Okay,
wanna accept that offer, then you can be done with it. If you don't, you're still gonna get released, but you need to make sure you're making your court dates going forward, otherwise you get.
absolutely,
All
Your Honor.
right. Attorney Baik?
For costs, Your Honor.
All right, so it'd be $114.50 for a plea of no contest or guilty to the charge of county disorderly conduct, if you wanted to accept that. And otherwise you can enter a not guilty plea. Did you want to accept their offer or do you want to contest the charges?
I would still be released, right? Even if
Either way, you're getting released.
okay, I would take the $114,
Offer and just be done with it?
yeah, I'd be done with it. That'd be better for me.
Yep, that's fine. I'll accept that as your no contest plea to county disorderly conduct, or you pay $114.50.
Okay, do I have time to pay that?
Yes, 60 days. You know, it's not like bail. You don't have to pay it to get released. So I
Thank
think
you.
you're gonna get processed and released yet today.
Okay,
And then you'll have 60 days to pay, or if you need more time, just contact the clerk's office.
okay, I surely will.
If you can work out a payment plan with them, it can be extended beyond that. They're gonna give you all that info.
Okay,
Any questions?
no, sir.
Okay, we are adjourned.
Thank you, Your Honor.
You're welcome.
Thank you.
That is everyone.